However, the right of minority is not absolute and it is subject to regulation. Reasonable regulation can be imposed for the protecting the larger interest of the state and the nation. While the imposing of regulation, the state shall be cautioned not to destroy the minority character of the institution. The preamble to our constitution aimed at securing the unity and integrity of the nation. Religious and the cultural safeguard have been guaranteed by the constitution and minority communities in order to ensure their justice, freedom of thought, expression of belief, faith, and worship. But if any minority community goes to clamoring for more than what the framers of the constitution offered to them, it would simply perpetuate in insular objective of these communities and India would be never grow up as a nation. Inspired with the ideal unity and integrity of the nation to revert to the anti-independence vortex of communalism and separatism would peril very foundation of the independence. On the other hand, secularism would means neutrality of the state towards all religion will itself be violated if the government suppress the religious or other legal rights of majority community appease the demand of aggressive minority. History of the right of property under Constitution of India. In Constitution 1949 had a threefold provision for the safeguarding right of private property. If not only guaranteed the right of private properties but also the right of enjoy and dispose of property free from restriction other than reasonable restriction. Firstly, a guaranteed is every citizen the right to acquire any property for any lawful means such as the inheritance, personal earning, or otherwise, to hold it as his own and dispose of freely, limited only by law, but only by a reasonable restriction serves to exigencies of public welfare and any other reasonable restriction that may be imposed by the state to protect the interest of any scheduled tribe. Article 19(1)(f). The Constitution of 1949. The restriction must be course. The restriction must of course be reasonable from the substantive as well as procedural standpoints. Thus, the restrictions must not be excess or the requirement of the interest of general public for which the restriction is sought to be imposed. A restriction would be procedurally unreasonable if in the absence of extraordinary circumstances it is imposed without the notice, without the learning, or without assigning any reason or the subjective satisfaction of the administrative authority. Secondly, the Constitution guaranteed that no person shall be deprived of his property save by authority by law. Article 31(1) that implies that the assault of consent of the hour a man of property can be taken only consent of the nation as embodied in the law passed according to the constitution. Any property which is seized by the police or the government without proper legal authority will be released as the intervention of the court as its own against its own subject. A sovereign cannot be exercised any act of state and the private property of subject cannot be taken away by the executive order. The distinguished from the order made is exercise power of conferred by the statute. This is clause was the intended to the protection against the executive but not against legislative appropriation of property. The Supreme Court, however, held that the law which seek to deprive a person of his property must be valid law, which means a law enacted by the competent legislator and not consistent with any of the fundamental rights guaranteed by Part 3rd of the Constitution. Thirdly, the Constitution enjoined that if state wants to acquire the private property of an individual or an requisition is to say to that over the possession for a temporary period, it could do so only on two conditions: that the acquisition or requisition is the public purpose, that when such a law passed it must be provided for payment of an amount of honor either by fixing or amount or any specify the principle upon which is to be determined and given Article 31(2). Amendments up to 42nd Act 1976. The provision of the Constitution as to the obligation to the pay compensation or acquisition of property for the public purpose. However, the underwent serious changes as the result of amendment of the Constitution by the first, fourth, 70th, 25th, and the 42nd Amendment Act. That is the net result of these amendments is as follows. Though the legislation was under the constitutional obligation to pay compensation, the adequacy of the compensation shall not be liable to the question in the court of law. In other words, when a law provided for the acquisition of personal property for a public purpose, he would not be entitled to challenge the validity of the law in a court of law on the ground that the legislator had not provided for payment of full value of this property. This Fourth Amendment 1955 in Article 31(2) was necessitated by the Act by the fact that even the word of compensation simpliciter was interpreted by the Supreme Court. The implement full compensation, the market value of a property at the date of acquisition. The government thought that is was not practicable to implement its program, the national planning and the development, if the full market value was to be paid from the unadequate resources of the infant republic for every inch of property which was the nationalized. But even after the foregoing amendment, the Supreme Court continued to hold that the very word compensation implied full monetary equivalent of the property taken away from the owner, is to say that the market value at the date of acquisitions. By the 25th Amendment 1971, therefore, the word compensation is the clause 2 of Article 31 was substituted by the word of amount, but again the majority of Supreme Court reserved an area of judicial intervention in full bench case of Keswanand and State of Kerala by holding out the amount which was fixed by the legislator could not be arbitrary or illusory but must be determined by the principle which is the relevant acquisition property. The Indira government reacted by the putting specified law the acquisition beyond the pale of Article 31 along together by grafting the expectation of Article 31D, which will be mentioned presently. By a number of successive amendments, certain exceptions by the Article 31(2) were introduced in Article 31, 31D, 31A, 31D. The exclude the obligation to pay any amount of compensation in the case of law providing for acquisition by the state or nationalization, if any such laws relating to matter specified in these exception provisions. These exceptions to the obligation under Article 31 may now be examined in particular. Article 31A realities. Article 31A relates to a law for the acquisition by the state of any state or any other intermediate interest in land. The object of taking out the acquisition of the intermediate interest of land and the obligation of compensation was the make possible for the government to effect agrarian reform, which was so urgently needed to protect the interest of tenants as well as the improve of agricultural wealth of the country. In order to facilitate agrarian reform as well as social control of the means of production, it has been provided in Article 31A that not only a law providing for the acquisition by the state of any state or any rights are therein or the extinguishment or modification or of any such rights, but also certain other laws such as a law providing for the taking over the or the management of any property by the state for a limited period either in the public interest or in order to secure the proper management of the property shall be continuously constitutionally valid even though it make away the abridges any of the right conferred by the Article 14 and the 19. While Article 31A accept certain classes of law, Article 31B read with the ninth schedule give a blanket over the particular enactment which are for the time being specified in the ninth schedule. Their number of 2000 in 284. They have been along together immunized from attack on the ground of contravention of any of the fundamental rights. Article 31C is inserted by the 25th Amendment Act 1971, provided that any law which seek to complement the directives of Article 39B or 39C, which is the plan of socialistic distribution of wealth and the means of production, shall not be void for consistency with Article 14 and 19. But the effectiveness of Article 31C was crippled by the decision of the majority of Supreme Court in case of Keswananda that judicial review is one of the essential features of Indian Constitution which cannot be taken away by the process of amendment under Article 368, and that accordingly the part of Article 31C which stated that any legislator declaration that a particular law was made to implement the directives and Article 39BC shall not be open to question in a court. It is itself unconstitutional. Undaunted by Keswananda, Parliament enlarged the scope of Article 31C by the 42nd Amendment Act 1976 by the including within the protection of any law to the implement any of the directives or principle enumerated in Part 4th of the Constitution. Not merely the Article 39B. As a result of this, if any law acquisition was made with the object of giving effect to any of the directives, if the reasonableness of such a law cannot be questioned under Article 14 or 19, Minerva Mills has, however, nullified with the extensions. The last fagot of exception, Article 31D, has been repealed by the 24th Constitution Amendment Act 1977 and needed not both and reader. While the Congress government forever a quarter of century had eaten into the vital of Article 31(2) of the successive amendment outlined above, it was the left to the Janata government is eliminated the right of property along together from the list of fundamental rights in Part 3rd. This has been affected by the 44th Amendment Act 1978, which have been already discussed the explanation with the judicial review. Nevertheless, this incident not be recapitulated in order to give to definite idea how so much of the right of property remains under the Indian Constitution after April 1979 and in what shape. Article 19(1)(f) has been repealed. Article 31(1) has been taken out of Part 3rd and made a separate article with 300A, which read as follows: no person shall be deprived of his property save by authority of law. The word law, which figures in Article 300A of the Constitution, would mean a validity enacted law. In order to be valid law, it must be just, fair, and reasonable. The compensation has been understood a relation to the right of property. The right of ouster is protected only limited extent enumerated in Article 300A of the Constitution. The result of sort is the individual property is taken away by the public official without legal authority or excessive power conferred by the law. In this behalf, we can no longer have a speedy remedy direct from the Supreme Court under the Article 32 because the right under Article 300A is not a fundamental right. He shall have to find a remedy from the High Court under Article 226 or any other ordinary suit. A clause 2A Article 31 has been omitted. Clause 2 of the Article 31 has been omitted, but its provision has been transferred to Article 30 as a clause 1A to the article. Through the Article 31 itself has been deleted. Article 31A was originally inserted in the exception to Article 31 has been retained with the omission of any referred to Article 31. Article 30A therefore remains to operate as a exception to the Article 14 and 19 to shield 5 classes of laws specified in the Article 31A(1). Curiously, however, the second provision to the Article 31A(1) has been retained, giving the right to full compensation to the actual tailor. Even though Article 31 has been omitted and interfered, the Article 31 has been omitted from the clause 1 Article 31, in which the second provision operates as an exception. The above patchwork is bound to create a confusion in the mind of lay reader. It would be accordingly to profitable outline the vestiges of the right to compensation which survive the onslaught of the 44th Amendment. These are twofold. Vestiges vestiges of the right of property and the comments thereon. Though the mass citizen shall no longer have any guaranteed right of compensation of the property is the acquired requisition, and the legislature shall have no consequential obligation to provide the payment of any solitium to the expropriated owner. Two exceptions to the general position are the allowed by the 44th Amendment to purchase of acquisition. If the property acquired belong to an educational institute established by the administrated by a minority, the law is acquisition must provide for such compensation as would not abrogate the right of minority to establish an administrative educational institute, which is the guarantee Article 31 of the Sound of the Unudo. This means that the state chooses the acquired minority education institute, it must full market value and adequate compensation, so the minority community may set up a institute at a suitable uh, alternative site. If the state seek to acquire the land which is personally cultivated by the owner, and such land does not exceed the statutory ceiling, the state must pay such owner full market value and on the land as any building or structure standing there on the appurtenant thereto. Though the both the foregoing exception may be beneficial for any they go, there is no much comment from the standpoint constitutional law from the national standpoint.